Yes, sir, Your Honor.
All right. May it please the court? Yes, sir.
I'll be honest with you, I thought she was going to say Dantel at the end there, because that's what it sounded like, right? That at the end of all that Dantel was the one, the hand. Ladies and gentlemen, my name's Case Brittain, and I don't want to talk at you guys. I really do my best not to talk at you guys. I'm here with my father, Tommy Brittain. I'm here with my younger brother. He hates it when I say that, Preston Brittain. I'll be taking a little personal moment here. This is the joy of my life. Probably the last time this will happen. I get to try a case with my father and my brother, but the actual brains are back at the office. I have a younger sister, and we have a new attorney too, Lauren Benton, and also a good staff of paralegals and assistants, which we couldn't be here without. That's the Brittain Law Firm plug. So I want to talk about our roles here today. I'm a little different than most people, most lawyers. I like to talk with you guys, and I know y'all can't really talk back with me, but if I just don't want to seem like I'm talking at you, right? It's very tough for me to do because I'm here and y'all get to say anything back. But I just want to kind of talk about our roles here today. Our role, honestly, as a defense counsel, if I wanted to, I'd go sit down over there. I'd go sit down, I'd go talk to Mr. Brittain. Mr. Brittain would say, look, we're not going to say anything else. We don't have to say anything. We don't have that burden. We don't have to say a word. We could let the state put up a witness after witness after witness, introduce evidence, introduce evidence, introduce evidence, and we could just sit there. Not question them, not cross-examine, just let the evidence speak for itself. The evidence, and we'll talk about evidence and the types of evidence here in just a second. That's what we could do, but we'll probably engage with the witnesses that we put up, and we might put up some cases and some witnesses too. Now the state, let's go back to the state in a second. You heard the judge, and I have to be very careful when I talk about the judge because he is the rule. He's the man, he's in charge here. Solicitor and I, we may get some little arguments about something, whether it's admissible. I may not like her tone, although I very much doubt that. She may not like that tone. I probably can get that way. Sorry. I apologize if I come off gruff at sometimes or condescending. I don't mean that. But the judge is the one that tells y'all or us if we are right or wrong. Sustained, whoever made that objection, it's allowed. Overruled, can't do that. He's that guy. And then he, of course, like he said, he instructs y'all on the law. And he'll do that at a later date. Now, the heaviest lift in this whole entire courtroom, maybe besides y'all, the state. You've all heard these glorious things before. The burden of proof. It's heavy on the state. Innocent until proven guilty, right? Innocent until proven guilty. The state has that burden to prove beyond a reasonable doubt. And another fun little term there, reasonable doubt, we'll get back to that as well, that my client, who is shrouded in innocence, was presumed innocent all the way until y'all say she's guilty, until the state proves that beyond a reasonable doubt. That's the burden they have through all their evidence that they have. Now let's talk about the evidence they have. You have usually two types of evidence. You got direct evidence, and you've got circumstantial evidence. Direct evidence, though, is like DNA, blood, crime scene photos. That's funny, too, crime scene photos. So I'm not going to say there's not a lot of evidence. I'm not going to say there's zero evidence, zero direct evidence. But in a murder case, I'd like to see a lot more. I'd like to see a murder weapon. Don't have it. I'd like eyewitness testimony. Don't have any eyewitness testimony. I like video of the crime. I don't have video of the crime. I like audio of the crime. I don't have audio of the crime. I don't have any of that. I don't have any of that direct evidence. The stuff that a murder case should have. Do you have the weapon? Well, but let's talk about circumstantial evidence, because this case is loaded with it. Now, circumstantial evidence, I like circumstantial evidence. It gets a bad rap in like TV shows, and you heard the judge talk about that in movies. You know, it wasn't me, it was the one-armed man, you know, that kind of stuff. Those things, it's circumstantial. I love it because it requires y'all to infer. It requires y'all to question. Does it prove what it says it proves? A really good example, and I have to give my brother credit for this. You walk outside, the ground's wet. You remember last night, Forecaster didn't say it was going to rain. Ed didn't say it was going to rain. So you think, well, maybe it rained. Also, possibly though, did your sprinkler system turn on? So what in the world could help you figure that out? Well, you kind of look over at your neighbor's yard. Well, his ground's wet too. What does that prove? Nothing, but except both your grounds are wet, because his sprinkler system could somehow run at the same time as yours. All right, so maybe you look to your neighbor to the left. Holy cow, his lawn is wet too. Now, if I'm the person that walked out and looked right and left, I'm starting to think, okay, it rained last night. I must have missed something. Quick shower. Hey, you live in Myrtle Beach, international waterway, rains in Conway, doesn't rain in Myrtle Beach. That happens, right? That's plausible. It's possible, all right? Then you look across the street, and it's like the Sahara Desert. Your neighbor's got not a drop of land over there. You look to the left of his house, dry as land over there, and you look to the right of his house, sprinkler system's still going on, and there's a flood going on. What do we know? We're pretty sure it didn't rain, and we're pretty positive that Earl on the end on the right there has got a flood. He forgot to turn the sprinkler system off, right? So the circumstance is different because of the way you view it. You have to add it. You have to link those chains. You have to see that the fact that your neighbor's yard is wet, that makes it a stronger connection that something happened that made the ground wet. It doesn't necessarily prove that it was rain or prove that it was sprinklers. So you look to your neighbor's yard. It does the same thing. It's wet, but it doesn't necessarily prove it. It does make the causation link stronger. But then you look across the street and you see that it's not wet. It's dry. So what do you know? You know that no matter how strong this link, it doesn't matter. It doesn't prove that it came from the sprinklers. But it doesn't prove that it came from the rain. You need that other inference. You need to look at all the surroundings, everything. That's what circumstantial evidence is. Now, in this case, we got a ton of it. A ton of it. Yes, you heard Madam Solicitor talking about the phones being together. Every single thing you heard Madam Solicitor say, guess who else was in there? Dantel. Then she goes at the end there, one of my favorite parts, the hand of one is the hand of all. So are they trying to tell you that you can convict Dantel? Just go ahead and convict Meagan Jackson too? Is that what they're trying to tell you? That if you can infer from all the evidence that Dantel is the one at the beginning of this, the end of this, the middle of this, and the one that has the most to lose, the one that has the motive? Deputy coroner, wife and kids? Meagan Jackson had written Greg Rice off. She's done. 15 years. Gone. See ya. Bye. She's already done something. She didn't need to do anything with him anymore. But a deputy coroner? Don't touch me, man. I'm a deputy coroner. He's got something to lose. That's motive. Again, circumstances. I want you're going to hear all kinds of evidence. We're going to try to cross-examine the best we can. Take each piece of evidence. Look at it. Look at the circumstances. Seriously. Most defense, when you've got a criminal defense attorney up here telling you to look at all the evidence, how many times do you hear that? How many times do you hear a criminal defense attorney say, look at this. Look at it. Look. Yeah, I know some bad things are going on here, but look. Really look at it. And if you can do all that, not worry about it. Because society's a little off. I feel like we want the worst sometimes. Flip on the news. War, gun, who got shot today? It's a bad time out there right now. Now I'm a little different. I really am. I look for the best in people. It's probably because I guess it's why I do what I do. I'm always searching. And it's not about me, but I'm always searching for the best in people. Every single person. Every single one. You. Everyone in here too. Love them. Don't know them. We have a chance in this courtroom, these halls of justice, to show that the presumption of innocence is paramount. All right? That innocent until proven guilty. Until proven guilty means something. Means something. It means that you don't convict somebody of a murder without a murder weapon. You don't convict somebody of a murder without any video of a crime or a shooting, any audio of a crime, of the crime they're accused of, or shooting, or any 911 calls from an apartment complex of that evening with 5 shots. No 911 calls. 0. We don't do that here. We don't convict on circumstances that don't add up. It's like baking a cake or making some soup or whatever, missing the salt. You have to have everything. You have to have everything. And I guarantee you, well, hold on a second. One of my big things I was told many times before I came up here, do not overpromise because you got to be afraid to underdeliver. Always got these little cliches. That's what I can't stand on this stuff. I just want to talk to y'all about it. I'm not trying to overpromise anything and underdeliver anything. I'm just trying to talk. We don't convict people on these kinds of charges, of these charges, of these serious charges, with no murder weapon, no video of the crime, no audio. Just don't do it. Presumption of innocence means something to people. We just can't do it. And I guarantee you, I hope that we can take ourselves out of this negative world, look at this evidence that's going to be presented, direct as much or as little as there is, circumstantial as much as little as there is. Remember that she's innocent until proven guilty. And look at everything. Everything. And say presumption of innocence means something. It does. And we will come back with not guilty. Thank you.
All right, ladies and gentlemen, before we begin the evidentiary portion, I think we're going to go ahead and take about a 10, 15-minute break, give you an opportunity to stretch your legs, use the restroom, whatever the case may be. Do not discuss the case even among yourselves. Leave your notepads in the jury box. We'll take about a 10 or 15-minute break, and we'll come back and get started. Thank you very much. Anything from the state before we take short recess?
Nothing from the state, Your Honor.
Anything from the defense?
Nothing from the defense, Your Honor.
All right, we'll take about a 15-minute break and come back.